Welcome back. Can the government tie you down like a dirty dog, stick a needle in you, and take your blood without your consent? Stick around and find out. My name's Attorney Patrick Silva. In this video, we're going to talk about forced blood draws, the government's authority, when they could use it, how they exercise it, and the limitations. Imagine this. You're driving down the road. You forgot to pay your tags for your registrations on your car, and all of a sudden you see red and blues in your rearview mirror. Woo, woo, woo. You're getting lit up. Your driving's fine. You went out with the guys or girls. You've had too much to drink. You're driving back roads home. You're almost there and you get lit up. Next thing you know, you're wearing a free pair of bracelets. You're hooked and booked and you're going to jail. You get to the jail and the cop tells you, hey buddy, you've had too much to drink, and under our state's law, and in particularly California, you got to give us a sample of your blood or breath. You might have watched too many YouTube videos and you're thinking, well, I don't have to give squat. I'm not consenting to nothing. The cop says, well, if you don't give it to us, we're going to get a search warrant from the judge, and it only takes us half a minute. We're going to send an email and he's going to get back to us in 30 minutes and you're going to have to give it to us. He gives you one more chance. You say, no, I'm not going to do it. Well, guess what? He gets the warrant. He comes back and he says, here you go, buddy. We're going to take your blood. Now, the question is a forced blood draw constitutionally legal, and what are the limitations on the government in doing this forced blood draw? We have to go back to 1966 when a couple of cases established that, hey, it's okay to forcibly tie you down like a dirty dog and take your blood from you. And that was a case called Schmerber versus California. And that's what came out of that case, was basically, yes, the forced blood draw was okay if the circumstances were exigent, i.e. were an emergency. That's kind of what that case law established. And then we come back up to 2013 in a case called Missouri versus McNeely. Let me back up. Schmerber versus California was a U.S. Supreme Court, went all the way up. And for years, from 66 to 13, I saw that the cops would, hey, you don't want to give us your blood? You don't want to do the breath? 6 dudes are coming in, tying your ass down and taking your blood. Now, 2013, McNeely comes around, U.S. Supreme Court, and it says, well, you know what? It's not that hard to get a search warrant these days with email and stuff. As a result, the cops get a search warrant and they could take your blood. Now, it goes back to another case, I believe it was Graham versus Connor, that said, well, we have to put a limitation on the force. And of course, in law, everything's vague. They said, oh, the limitation is defined as reasonable force. What the hell is reasonable force? Let's go to the scenario. Now he's tied, he's got the warrant, he comes in and you're still saying, nope, I've watched YouTube videos, they say I don't have to do blood or breath. Next thing you know, you got 6 dudes walking in wearing uniforms and they say, give us your blood or we're going to hold you down and take your blood. And all the clients I've done, I've seen a few that say, nope, I ain't giving it. And guess what? They take your blood. And what's the ramifications of that? You know what? The next thing you're going to do is they're going to give you a disorderly conduct charge because they're saying that you're being uncooperative, and when you twisted your arm a little bit because you didn't want the needle taking your blood, they're going to call that resisting. Obstruction of justice. And then when you squibbled, they're going to say, oh, you almost kicked Johnny the officer. And next thing you know, you got a resisting arrest charge, or maybe in California called a PC-69 or PC-148 charge. It ain't good. Now, why do they charge these charges on a resisting arrest case? The reason I see it is because if they harmed you, then there's a high probability you might go see a civil rights lawyer and try and sue them. Because do you have a right to resist an unlawful taking? Law's gray. Let's say it's yes, let's say it's no, but you find a civil rights lawyer and he says, you know what, I'm going to fight this for you, Silva. I'm going to make sure your day in court's heard and we're going to get justice. The reason the district attorneys throw on that 148 or PC-69 is because if they get you to plead to that, even if you're not doing any jail time, then they have a good defense in the civil end. So recap, can they take it? They're going to get a search warrant, check, yes. Are they going to use force? Yes. And the question is what is reasonable force? Hope you liked this video. Stick around for the next one. Patrick Silva out. Have a great day. Bye.